All right, so now we'll move to our public workshop, code amendment related to required findings for approval of subdivisions.
And this is also an item that was identified in our audit for the comprehensive plan. It appeared that we needed to add a few findings in two places within our municipal code, one in the land division ordinance and one in our project review procedures ordinance, respectively Title 18 and Title 15 of the municipal code. And I have put on the dais in front of you there a legislative format type of a copy showing where we would add some verbiage that basically require that findings be made that for any subdivision that the public interest has been met or served through the approval of that subdivision. In particular, there are a number of different things that we have to look at. One of the two items in particular are proposed to be added, and that's on the second page of that handout. Provisions have been made for all necessary streets, alleys, sidewalks, transit stops, and safe walking routes to school. And it's especially that latter item, safe walking routes to schools, that has been recently added to the state law. And then schools and school grounds, which is something that we just hadn't had in our subdivision code. And so those are the additions to the subdivision code. And then under our procedures code, it just amends under the review process 2, which is for most of our smaller subdivisions are reviewed administratively, that we make the similar findings about the adequacy of the infrastructure that's provided, and that including the safe walking conditions for students who only walk to and from school, and that the public use and interest will be served by the platting of such subdivision and dedication. Similar findings would be required under the section for the hearing examiner for those subdivisions that are reviewed through that public process. So pretty straightforward, I believe, those changes. We don't anticipate that we'll have to amend these significantly before we have a public hearing at a future meeting. This will probably come back to you a little bit sooner than the prior item on the definition of family. Just we don't see that there are a whole lot of issues. It's pretty standard stuff that most municipalities have in their regulations concerning subdivisions.
Okay, thank you. Comments from the commission? Commissioner Sand?
Alan, I noticed that parks were not listed as part of the public services on the, we got to item 9.
Right.
Right. It is under existing facilities, but wouldn't it be appropriate to have it under the prior section as well? That they would provide park and lieu fees or actual dedication of land to provide for parks and recreational activities.
And as you point out, it is under, it's already in the code in the following section. I'm just trying to understand the difference between the two.
The following section talks about existing facilities and not adversely impacting those facilities.
Right.
I'm talking about obligations that developments would have towards providing for additional.
No, that's a good distinction between, adding, for example, typically the way a jurisdiction would respond to that would be either to require provision of a public or private recreational facility within the subdivision, or contribution toward park impact fees or something of that nature. And we do require in our subdivision code provision of, at least for larger projects, more than your short plat type situation of up to 9 lots. Larger projects have to provide some on-site recreation, and that's typically the way that we do it. But putting a provision in the subdivision ordinance is probably a good idea. And maybe this won't come back quite as quickly as I had stated a moment ago. I'll have to run this through the legal department, but also our Parks Department. I know that there has been some reluctance in the past to initiate collection of park impact fees in the city, and I think that's probably a policy question that should be going through the Parks Commission before it goes into an ordinance like this, but I'll have that conversation with the Parks Director and legal staff and administration to just see if that's something that, I know that it's been discussed in previous workshops that we've had on the capital facilities element of the comprehensive plan, and that hasn't fallen on deaf ears. It's something I think that we've had some discussions about with the Parks Department, but I think that's a larger, broader policy discussion that has to occur with the Parks Commission. But I'll see how that might work within the context of this code amendment with the legal department.
And then I was also wondering if number 8, where it talks about provisions for necessary streets, alleys, sidewalks, transit stops, and safe walking routes to school, also would cover the situation where you would have to kind of fill in some gaps or provide for connectivity between a new subdivision and the existing, and that connection might actually be off-site.
Mm-hmm.
So it's functionally connected?
Right, and I believe there's another section in the subdivision code, which I didn't bring with me tonight, that does give us that ability to make that connection, but I will follow up on that, and at such time that we bring this back, respond to that issue.
Okay, thank you.
Yeah, Commissioner Adams?
Alan, I have a few more typo things for you.
Okay.
So in your revisions, you have city capitalized. In your prior drafting, the city's not capitalized. So,
Okay.
So just a small issue there. And then on the second page, on number 6 at the top, you have a leftover "and" that needs to be moved down to number 8. So, sorry.
Appreciate those grammatical
Which my
and
comments were more
formatting
substantive,
questions.
but I agreed with Lawrence, that was good. So.
It's good, everybody's carefully reading.
I appreciate that, thank you.
Other comments? Okay. Opportunity to hear from members of the public regarding the proposed code amendment to the subdivision code. Would you like to speak? Okay. You can approach the podium, and we do have a half sheet you can fill out later if you would like. And if you wouldn't mind saying your name for the record, as well as your address, please.
Okay. My name is Rick Hart. I live at 7714 78th Place Northeast, Marysville. I've been a land use consultant for 25 years, worked a lot in the city of Everett, and in the past, on small subdivisions in existing neighborhoods, short plats, we were allowed to contribute so much per front foot toward a sidewalk fund in lieu of building frontage improvements, where they might be the only frontage improvement for many blocks, one way or the other. For maintenance for the city, upkeep, just didn't make any sense to do that. Well, in the last year or so, there's been changes, apparently in the state law or some other jurisdictions, where that's no longer, you can no longer do that. You can't collect money, is what the staff has told me, where the money's not going to be used to benefit your particular property specifically. But certainly, I think it'd be beneficial for the smaller developers, lot developments in the city of Everett, if there was a provision where we could pay into a sidewalk improvement fund that would fill in those gaps, for an example, rather than doing something along the street that doesn't benefit anybody. Thank you.
Thank you. Anybody else care to speak to this item this evening? Seeing none, then turning back to the commission, any other items you'd like staff to consider when reworking this before they bring it back to us? Commissioner Adams?
Alan, is it possible to address the comment that was just made? Give us some background on that.
Sure. And this is one I'll answer in two parts. And Mr. Hart is right. The city did used to allow for the deferral of frontage improvements in the neighborhood where there might be only one lot on a street or a couple lots on a lengthy street that had the possibility of being subdivided, and the city would take an in lieu fee rather than requiring those frontage improvements because it would not result in continuous improvement along the entire street. A couple of comments related to that. One is that we do now collect transportation impact mitigation fees already when there's a new single-family dwelling constructed, and so those are the fees that are used for transportation improvements that benefit the general public, but also that development to some extent. It may be on an intersection improvement that traffic from that subdivision would use. But also, the city has in the past allowed for the signing and recording of LID covenants so that at some point when we had enough of those covenants that we could form an LID to do an area-wide improvement. Those just haven't been very successful, and so the change in philosophy in our engineering department has been just to get the frontage improvements at the time of the subdivision rather than try and track the money or the covenants for an LID for something that probably wouldn't result in like a local improvement district that would be big enough or cover a very substantial improvement. And so we do end up with some piecemeal type frontage improvements as subdivisions our short plats in particular are developed within the city. Notwithstanding the earlier discussion about requiring a connection for safe walking routes to school, where I believe our code does give us that authority, and I'll verify that before I come back the next time with this one. But that's just a change in the philosophy of our city engineer and compared to the practice that we had been using for a number of years.
So we end up with sections where you walk along the street, go up on a sidewalk, back down onto the street. That's essentially what the
Yes,
result is, right?
and that's, you can see that in a number of areas of the city where either in much earlier times we had required the frontage improvements, and we went for a time with the in lieu fee or the LID covenants. But more recently, it's been going back to the actual frontage improvements for the property being developed.
Okay.
It seems to me that maybe there's a reasonable trade-off that could occur in some fashion. Because when you're talking about full frontage improvements, it's usually a curb, gutter, sidewalk, and widening out the street to whatever the prescribed width should be of that road section. And I mean, I know it doesn't make a whole lot of sense to have a piece of concrete sidewalk in the middle of nothing. But then there's a cost, or there's an investment that the property is obligated to fulfill. And I would think if there's a way that we could take those monies that would have gone into a concrete sidewalk that could be then gone into an asphalt walkway or a widening of the pavement, creating a safe shoulder, pedestrian route, whatever, so that so there's an actual improvement of some type. Maybe it's not the final improvement, but maybe in some neighborhoods of the city, the final improvement just doesn't make a whole lot of sense. But yet I don't see that we should allow the developers to kind of walk away from that responsibility as well. So I don't know if there's a way to kind of do some horse trading here of what their financial obligations would be for full improvements, and then have them make likewise improvements off-site.
Okay. And this is not something that really is the focus of the item that is on the agenda, but it is a good discussion that I can pass along to our engineering folks, and just bring that up, that Commission was interested in this topic as raised by Mr. Hart, and we can perhaps have some follow-up dialogue about that in a separate process.
Thank you.
Madam Chair, before you head for adjournment, I did have one other non-agenda item that I did have that briefly mentioned for you, but don't want to cut you short of this discussion. I just didn't want you to adjourn yet.
Okay. Any other comments? I don't think we have any other comments on the proposed code amendment for the subdivision, so I
Okay.
think we're ready for your item.
All right, thank you. This next one actually is what I thought Mr. Hart was getting up to talk about. He did submit a letter and a fee to accompany a request to initiate a code amendment to reduce the minimum lot width in the R2 zone from 50 feet to 37 and a half feet. And by way of background, we do allow for a minimum lot area in the R2 zone of 4,500 feet, and most of our lot pattern in the north end of the city is with 120-foot deep lots. And so to get, for example, if you had, let me back up just a moment. The typical lot pattern in the north end is 25-foot wide lots by 120 feet deep. And so if you had an assemblage of 3 of those lots, which is not uncommon, for 75 by 120, that gives you a 9,000 square foot lot. If you were to divide that right down the middle, you would have a 4,500 square foot lot, 2 of them, but your lot width would be 37 and a half feet. Our code requires a minimum lot width of 50 feet. We're not ready at this time to ask the Commission to initiate the request, but I did want to bring it to your attention because Mr. Hart has paid a fee to bring it forward. I have not yet had the internal discussion with my legal department and the Public Works Department as to whether or not that's something that we would support. And before we would ask you to initiate this and then ask Mr. Hart for another $5,000 to process the code amendment, want to have some indication for him whether or not this is something the staff would support. We do already have a process whereby that 9,000 square foot, 75-foot wide lot can be subdivided, but it's a subdivision process which, as we've discussed, requires frontage improvements or impact fees. When you have 3 25-foot wide lots and you have a house built over the internal lot lines, our code requires or designates those as merged lots. If you take that house away, then I think Mr. Hart's interest would be to be able to just use those existing lot lines as though they were never merged, or do a boundary line adjustment so that you're creating these 37 and a half foot wide lots and getting 2 lots where you had two 37 and a half foot wide lots where you used to have a 3 25-foot wide platted lots. So I think I'll also suggest that you have Mr. Hart come up and talk about his interest in this, but I wanted to at least let you be aware that we're looking at this. It's not something we're ready to recommend yet. I need some legal interpretation from our city attorney and some feedback from our Public Works Department before I would ask or put this on a future agenda. So that's the end of my comments.
Okay. I know Mr. Hart is here this evening, so would it be all right if he came up and?
I would, yeah, sure,
Okay.
I would encourage
All right.
that.
Good, thank you.
Again, Rick Hart, I wasn't really anticipating doing this, but thank you, Ellen. There's really two different situations. One is the example that he mentioned, the 3 25-foot contiguous lots under one ownership where the old house is torn down. It's 9,000 square feet. Because of the time involved and money, builders often choose to build a duplex. 7,500 square feet, R2 zoning, do a duplex with no additional fees. Well, personally, most builders would rather build 2 single-family rather than 1 duplex in these single-family neighborhoods. So this code amendment would allow that to happen and still satisfy the 4,500 square foot minimum, but allow us to build single-family lots too, rather than a duplex, without going through the short plotting process. Time, money, hassle. Do you want duplexes? Want single-family? That's one example. The other example, on some of these old platted subdivisions from many years ago, usually the lots are 25 foot by 120 feet deep, but sometimes where the subdivision ends, or there's a right-of-way, you end up with a smaller than 25-foot lot. I've worked on a piece right now in North Everett where we have 4 contiguous lots where we tore down the house. 25, 25, 25, 20. We went to the city staff. Initially, they said, no problem, 2 building permits. Came back later, they got out the code, Mr. Hart, 50-foot wide. Sorry. These were 5,000 square foot wide lots, but because we did not have 50-foot wide, even though we had 4 lots, we're stuck. So I have a builder now that's trying to decide, should he buy property from the neighbor, vacated right-of-way, short plat, whatever. So that's the other example of where trying to be more flexible in the lot width, because the code was changed to allow 4,500 square foot lots in R2 zone where there used to be 5,000. It went from 5,000 to 4,500, but the lot width was not reduced from 50. So they gave us the smaller square footage, but they kept the 50-foot wide lot. So they kind of gave, but they didn't give us any benefits. So those are the 2 examples. One is allowing us to take these existing platted lots, do a BLA to accomplish the 37.5-foot wide, 4,500, or if we have 4 lots even, just to say, okay, two of the merged lots together, 37.5 feet wide, would be considered a buildable lot without any BLA or any short plats, just merging the lots together. So the one in North Everett, we would have 4 lots, 2 of them would be merged 50-foot wide, the other 2 would be merged 45-foot wide. Any questions?
Commissioner Sand?
How does your proposal relate to the obligation for frontage or off-site improvements that are triggered through the subdivision process?
I'm not sure right now if we tear down a house and we create, 2 buildable lots. I know we have to pay water and sewer capital improvement charges. I don't know if the current code requires us to pay school mitigation fees on the new house or not. We do, so we already have to do that. So it wouldn't affect the school fees at all. Frontage improvements is a good question. The one in North Everett has full frontage improvements already, so not an issue. In some instances, frontage improvements could be an issue, so So that could be a requirement, that either we do frontage improvements and/or pay into some fund.
So you're not looking to, I hate to use the word avoid, but to avoid financial obligations, you're looking to reduce time in the
Well,
process.
Short plats, used to
Or
be.
predictability.
Used to be $500 to do a short plat in the city of Everett. Now it's $5,000.
Yeah.
Used to be, well, whatever.
Yeah.
It takes a long time to get through.
Yeah.
Besides the obligations and
Sure.
consultants, and I'm a consultant, so better be careful what I say about consultants. But, it costs money.
Yeah, I started in this business on the other side of the fence nearly 50 years ago, so I know the process has changed tremendously. And I think there's value in finding a process that's expedient, so long as we get the same obligations and commitments and quality product.
Right. And it's interesting that the short plat code in R2 zone with LA access would allow you to go down to a 30-foot wide lot and 3,000 square feet for a single-family lot. So I'm not asking, I'm not asking something that can even be achieved by a short plat. I'm just saying 4,500 square foot lots. So these are much larger lots than what could be achieved through short plats, which, if you like small lots or don't like small lots, that would be another consideration.
I think it's worth talking about, but I think we need to allow Alan some time to investigate things and get a.
Yeah, I've got an internal meeting scheduled next week, so I should have something that I can bring back to you in the fairly near future on this one. I'll be working with Mr. Hart in the meantime to just understand this a little bit better, and we'll bring something back one way or the other. If it turns out that we don't recommend that approval, that just means that, you still have the opportunity to make a different decision than our recommendation, but we certainly want Mr. Hart to have his due process here.
Great.
Thank you.
Thank you.
Commissioner Adams?
Alan, and maybe this doesn't apply at all, in the R2, do the unit lot subdivisions apply in R2?
Not in this limited of a application. The unit lot subdivision, and
If you could build a duplex, couldn't you do the unit lot subdivision on top of the duplex? I'm just trying to think historically, what we've done with other types of discussions in terms of density and lot size.
I don't believe so, but I'll take another look at that. You could do a condominium, but as we heard, as we were going through that process, people didn't want to
Right.
do condominiums.
Absolutely.
So, yeah, I can check into that as well when we bring this back.
Okay. Thank you.
Thank you.
Okay. Anything else for the good of the order this evening? All right. So our next meeting will be on June 16th. We are adjourned. Thank you.
Thank you.